Here we have our last lesson for Unit 4, and that is Lesson 20, What is Due Process of Law? And Lesson 20, in fact, follows up on the information we learned about the Bill of Rights in Lessons 18 and 19, and we continue with the TEKS 19b that we can summarize the rights guaranteed in the Bill of Rights. So first of all, let's define what's meant by due process of law. And what that means is the defendant, and this is the person who is on trial, that the defendant has certain rights and must be treated fairly throughout the judicial process. And this applies both to criminal law and to civil law. So when we talk about the idea of being treated fairly and having rights, this means that the defendant is assumed to be innocent, which means that they did not commit the crime unless they are proven to have done so. And due process protects their rights along the way so that at no point they are presumed to be guilty and treated in that way. So let's look at what this actually means. So going through the steps. Okay, a crime has been committed and the defendant has been arrested. First of all, there will be no search and seizure without a warrant or probable cause, and that's covered by the Fourth Amendment. The defendant will have the right against this. It also means that they will be read their Miranda rights to remain silent and have a lawyer under the Fifth and Sixth Amendments. Now, you're familiar with Miranda rights if you've watched any police shows or lawyer dramas of any sort, where they go through, you have the right to remain silent. If you give up the right to remain silent, anything you say can and will be used against you, and you have the right to an attorney, and if you can't afford one, one will be appointed. So anyway, they take you through your Fifth and Sixth Amendment rights to remain silent and to have a lawyer throughout the process. If you're accused of a crime, you go to what's called your arraignment before a judge with your attorney and the prosecutor. First of all, they had to tell you what the charges are against you according to the Sixth Amendment. You have to be indicted by a grand jury to go to trial. Like we said in Lesson 19, a grand jury is a group of citizens who look at the evidence and they decide whether there's enough evidence to warrant taking the defendant to trial. At the arraignment, the defendant has the right to ask for a reasonable bail. And again, that bail will be lower in the case of misdemeanors, which means lesser crimes, and much higher in the case of felonies, which would be major crimes. And also, a trial date will be set by the judge, and that trial date has to take place just as soon as possible, because again, it's not fair if the defendant should have to go to prison or should not be granted bail. It's not fair to make them wait in jail longer than they have to, or to have to sit around and wait for a trial, wondering what's going to happen to them. And that's covered by the Sixth Amendment. So the trial happens. First of all, you have the right to a lawyer at that trial, and in fact, you'll have a right to the lawyer throughout this process according to the Sixth Amendment. Also, according to the Sixth Amendment, at that trial, it will be a jury that will decide the case, and it will be a jury of your peers, meaning local citizens. And the trial will have to take place in the area where the offense occurred. At that trial, your attorney will also have the right to call witnesses for your defense and can cross-examine prosecution witnesses and prosecution evidence. And in fact, the prosecutor must show the defense all the evidence that they have against them according to the Sixth Amendment. And finally, like we said, plead the Fifth. You don't have to testify at your own trial. An example of this, again, we talked about the O.J. Simpson case, where because if you choose to testify, then you also open yourself up to cross-examination. So it's the choice of the defense whether they will testify. And again, the choice to testify or not is not considered evidence because, like we said, the defendant is presumed to be innocent. So the trial is over, and in this case, the defendant is acquitted, which means found not guilty. So there will be no double jeopardy. That trial is over, and they cannot be retried under the Fifth Amendment. Now, that does not mean that they can never be tried again for anything. It just means that that particular accusation, that particular case, is over. If they are convicted, which means found guilty, if there will be punishment, the punishment has to fit the crime, and it can't be cruel. Like we said, lighter punishments for misdemeanors, more severe punishments for felonies, but even severe punishments, right up to the death penalty, cannot be cruel and designed to intentionally inflict pain or cruel and unusual punishment. Now let's move on to civil cases, which means non-criminal, like we talked about, property or family. At that, you will have the right to a jury trial under the Seventh Amendment. That the state cannot take away property without due process. You're entitled to a hearing. And that if they do take away property, for example, we mentioned eminent domain, the state needs something, needs a portion of your property for something they want to do. that they had to pay a fair price. That's according to the Fifth Amendment. So what happens if due process is not followed? Well, the judge can exclude, which means the exclusionary rule says the judge can remove any evidence that they think has been gathered without following due process. For example, if they think that a search and seizure was not constitutional, or they think that your rights into a fair trial were violated at any point, then they can exclude that evidence, and in fact, they can even just outright dismiss the case, regardless of any other evidence that the defendant may be actually guilty or innocent. Again, the idea is that they do not want to convict somebody without providing due process, and it's the judge's discretion to determine whether that has happened. So that is why due process is so important, and why prosecuting attorneys, judges, and defense attorneys must be very careful to make sure that it's followed all the way through the judicial process. So our Lesson 20 thoughts: list at least one item from each of the 5 due process amendments, and by that we mean 4th, 5th, 6th, 7th, and 8th, that protect the rights of accused persons. Which one do you think is the most important, and defend your choice? And we will see you for our next unit in Unit 5.